This video is about, as you can see, popular case law that has an impact on our studies as well as the application of the company law in our day-to-day life. So first one is Solomon versus Solomon Company Limited case. You can easily discuss, identify, and analyze the case by looking at some online sources. So I don't need to tell the full story about it. This is basically about the difference between the company and its power to make contracts and be responsible for the contracts, and the members and the directors who are not exactly responsible directly for the company contracts. This is the case that determine that aspect. Here, a director who was the only director, right, and the biggest shareholder having 99% shares, were held to be not responsible for the losses that the company suffered, because he was just a director and a member, and the company should be fully responsible for the contracts that the company makes. So we call it separate legal personality. That's the company, what company gets, right, when the company registers itself. It's a pretty interesting case. Even though this particular person, Solomon, the Mr. Solomon, let's call him, was the only director and he had 98%, 99% shares. And there were only about 5 shares of the company that was shared among his wife and children, 1 share each. The court said no. Still, the company is responsible for the contracts made, not him. So we call it as the power of the company when it comes to the separate legal entity or the separate legal personality. A very interesting case. Go through the facts of the case as well. Next one, the Hickman versus Kent. Yeah, Romney Marsh Sheep Breeders Association. Rather old case. It's about the articles. Articles of the company covers directors and members. So the members have the right to follow the articles, and the directors have the duties as well as the power, rights, to go through the articles, content in the articles. So articles is a main document when you apply for the registration of a company. What's in the articles cannot be broken neither by the members nor by the directors. So here what happened was, and by the way, there's another thing. The articles of the company is set by the company itself. So the company is free to set up its own article. So it can have various aspects written as per the needs of the company. So uh, both the members and the directors are governed, right, by the terms included in the articles. Violation of the terms may result in them being personally liable. Next one, the powers and the duties of the directors. Now, duties and the powers of the directors are set by the articles of the company, but then there are automatic duties for the directors also. Typically, the directors' duties, because they are directors of a company, we call them the fiduciary duties. Now, this case is about one such case, Hutton versus West Cork Railway, very old case. It's about directors kind of using company money to pay the employees gratuities. But there the court said, directors cannot use company money for purposes like this unless this particular purpose is for the benefit of the company. You can't use company money for just for charity. The director's action here, although it was for the benefit of the members, the court decided as not beneficial for the company. Directors have a duty to be, yeah, doing their conduct, carrying out their activities to the benefit of the company as a whole. So that's the key fiduciary duty of the directors. Another case, Foss versus Harbottle. Again, with regard to the powers of the shareholders. Shareholders cannot directly take action against the directors. Shareholders and the directors are all part of a company system, However, if the directors have done a wrong thing, as per the understanding of the members, the majority of them can take action to remove the directors by a vote, actually. Majority of the members can remove the director if they're not happy with the directors. But ability to take legal action against the directors is not there for the members. Members cannot directly take legal action against the directors. They can take action, however, with the permission of the court, right? If the court gives them permission, they can file action on behalf of the company. Imagine that the directors have done a wrong thing, one director has done a wrong thing, and it's bad for the company, but the company is not taking legal action. There, a member can get the permission of the court to file legal action on behalf of the company against the directors. But individual shareholders cannot take legal action against individual directors. Company can take action, but not individual shareholders. Another one, yeah, what sort of legal protection you get? There's a thing called the wheel of incorporation. When you're a director of a company, your conduct, your decisions and actions are protected from legal action by outsiders. So we call it the veil of incorporation. So it's not possible easily for outsiders to take legal action against individual directors for a wrong done by a company or a wrong thing done in the name of the company. Outsiders can take action against the company, but they cannot take action against the directors. There was this case called Guilford Motors versus Horn. Now, there what happened was there was this, when you are a director of the company, you have to come under the articles. And articles govern the act of the directors. Directors have to work according to the rules set by the articles of the company. Now, who set the articles? It's the members of the company who can set the articles. They can change the articles also with the support of 75% of shares. Now, in this particular case, a director tried to avoid his legal duties given in the articles because it clearly said this particular articles of the company said that the directors cannot do business with the clients of the company. So what the director did was he set up a company in his wife's name, another company, and used that company to do business with this company. The other court said no. Here the contracts were made simply for the purpose of avoiding legal duties. He had a legal duty as the director of the company to follow or abide by the articles, where he was not supposed to do contracts with clients of the company personally. In order to avoid it, what he did was, set up his own company, rather under the name of his wife to do the contract. So there the company was created by the director for a bad purpose or a mala fide purpose in order to hoodwink or in order to sidestep the law. The court said no. You cannot set up a business, you cannot set up a company for the purpose of avoiding the legal duties. So there the director was held personally liable. Although the contract was made by this company set by his wife with the company where the director was already a director, the court said this cannot be considered as a contract that is okay because the contract was set for the purpose of avoiding or sidestepping the legal duties the director has. Another case, Makara versus Northern Assurance. Now, what happened there was, this connected to insurance also, right? Um, If you look at the case, take a look at it. Makara owns shares in a company but insured timber in his name. You can't do that. Nobody owns property in a company unless it's a company itself. Outsiders or individual people cannot own the property of a company. Company property is owned by the company. Company either buys it, owns it, or rents it, or leases it. Property of a company cannot be in the name of another person. So here, what happened was, um, he sort of created a company using his own property, but the timber, that means the wood that would be used for making planks and all, he tried to insure it in his name. There, the court said no. Company property can only be owned by the company. Individual directors cannot claim ownership to company property. This one, Regal Hastings versus Gulliver. So what's that? Now, there the directors sold a subsidiary of the company and made some secret profit. And they did not disclose the profit to the main company, the parent company. There the court found out that directors have a duty to disclose their incomes, their profits. Failure to do so is a violation of a fiduciary duty of directors, of being in good faith to the benefit of the company. So, few cases, and all these cases, right? These are just introductions to the cases only. It'll be better if you do further research about these cases online and get a deeper understanding of these separate cases. So in this particular video, what I've discussed was about separate legal personality, will of incorporation, limited liability, as well as members and the directors' rights and duties. Hope this video would have helped, and catch you in another case related video.